everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me once again is criminal defense attorney Phil Harvey. Phil, thank you so much for joining me.
Thanks for having me, Brittany.
I want to get your legal perspective here on some big news involving former president as well as his wife this week. A handful of Democrats joined Republicans on the House Oversight Committee to vote in favor of holding former President Bill Clinton as well as former Secretary of State Hillary Clinton in contempt of Congress. And this all stems over their refusal to comply with a subpoena to testify in front of the committee about their relationship with the disgraced financier and convicted sex offender Jeffrey Epstein. So to start off the conversation, what do you make of the news?
Well, Brittany, certainly this was the expected shoe to drop after the Clintons refused the congressional subpoena. We've already seen individuals like Peter Navarro and Steve Bannon charged, convicted, and sentenced in similar instances where there was a refusal to comply with a subpoena, and now the House is seeking to do the same thing for the Clintons.
I do want to jump the gun here and ask the question that's on everyone's mind, because you brought up two of President Trump's past advisors, Peter Navarro and Steve Bannon. Both of them served jail time after they were held in contempt of Congress. They refused to comply with subpoenas from the January 6th committee. So based on that, you see that. I'm curious, do you think the Clintons will actually face jail time here?
They could, Brittany. The total sentence possible is up to 12 months on each count. So each individual in this case is looking up to 12 months and a $100,000 fine. Now, I believe the fines for Navarro and Bannon were both under $10,000, but each of them did spend 4 months in jail.
And so let's just take a step back here. Let's first break down, if you could, the Clintons' argument. I want to talk about some things that they said, because here's how their legal team described the subpoenas. They said they were invalid and legally unenforceable, untethered to a valid legislative purpose, unwarranted because they do not seek pertinent information, and an unprecedented infringement on the separation of powers. How strong is their argument here that the subpoenas cannot be enforced?
Well, Brittany, of the litany that you just mentioned, there is one key point, and that is the information sought relevant to the congressional inquiry? One of the elements of the crime here is that there are three main elements. One, you have to be summoned. Two, you have to have willful noncompliance, which a letter stating that you refuse to comply is pretty strong evidence of that. And third, the Congress will have to show that they were seeking relevant information. And so the Clintons' letter stating that this was not for any lawful purpose and that there was no relevant information to find is a possible defense here.
I do want to pick your brain about what has been reported as an off-ramp compromise that the Clintons team tried making with Comer's team. They said that they would have a meeting under oath in the former president's office. Comer would be there, as well as the ranking member of the committee, as well as a staffer each. They would have this meeting. Comer rejected it, but do you think the Clintons could use this as a sort of defense and say, hey, well, we tried speaking with you here?
You know, as far as a defense to the elements of the crime as defined, Brittany, I don't think that's a legal defense. Certainly it's something that the House can take under consideration in terms of deciding whether to eventually move forward with a trial in the matter. And so the House could decide, in light of all the circumstances, that the Clintons' willfulness and not complying was more excusable in this case, and maybe they shouldn't move forward. But at the end of the day, they did send a letter saying they were going to refuse to comply with the summons. So while not a legal defense, it might still serve to get them out of some hot water.
The Clintons also argued that they're being held to a different standard here, that other people were issued subpoenas, other officials, and they gave written testimony, and the House committee thought that was enough. The Clintons said, hey, we gave written testimony. You're still trying to march us in here. It's a political performance, essentially. Does that bolster their argument at all?
Brittany, those are all relevant considerations in the big picture of what's going on. And we see this not only with prosecutions of political figures, in circumstances like this, but even in the day-to-day criminal prosecution and defense system. All cases are not treated equally. And so it's again, while not a legal defense saying other people were treated differently, it may serve to bolster their position in negotiation and perhaps, cut off at the pass the idea that the House is going to want to take them to trial.
And to that point, the Clintons have argued that Comer and Republicans here are playing partisan politics, but Republicans and Democrats voted in favor of this subpoena, not only to subpoena the Clintons, but to hold them in contempt as well. So can you really argue that this is partisan politics here when Democrats are voting with Republicans side by side?
Well, Brittany, that's a great political question. And, I certainly think they have an argument to make there. But it's a little bit, it feels like a stretch to me to say that a bipartisan vote and a bipartisan decision to move forward with the subpoenas and the prosecution here seems like a stretch to call that partisan.
I know that we talked about the Clintons making reportedly that off-ramp offer to talk under oath in a meeting in the president's office with both Comer as well as the ranking member. But Comer said that this was an untenable offer, his words, and he said it is insulting to the American people who demand answers about Epstein's crimes, and also added this: former President Clinton has a documented history of parsing language to evade questions, responded falsely under oath, and was impeached and suspended from the practice of law as a result. What do you make of that as a lawyer? You hear that, what do you think?
Again, Brittany, I think there are a lot of partisan political blows going back and forth here, and it's within character, I think, for Comer to make that sort of statement. If you really boil it down, what he's saying is this is not the kind of case where a behind closed door questioning is appropriate, and this is the kind of case where an open congressional hearing is appropriate. And so the content of what I think Comer is saying there could be fair, but it's certainly charged with a lot of partisan language.
I do want to take the politics completely out of this for a second, or try to, because this is really, as you said, stewed in partisan politics. It's being viewed in a partisan lens, right? If you're a Clinton supporter, perhaps if you're a Democrat, you're thinking one thing, maybe. If you're a Republican, you're probably thinking a different thing. So when you take the partisan lens off here, when you're looking at this and boiling this down from the view of a defense attorney, what really matters here?
I think it's understandable that this committee wants to have an open line of inquiry and questioning with Bill and Hillary Clinton, given how much Jeffrey Epstein was at the White House during his era of popularity. And the thing to keep in mind, Brittany, is that this committee is not saying either of the Clintons did anything wrong. They're saying they have relevant testimony to this investigation. And so the contempt charge is really, if you keep that, the fact that this is an investigation, it's not an accusation. If you keep that in mind, the contempt charge is really saying that the Clintons are obstructing an investigation. It's not saying that they're covering up any wrongdoing. So when I put my lawyer hat on and I think about trying to potentially defend a client in this situation, I think one of the considerations is, if you don't have anything to hide, you generally want to comply with this. And if you don't feel like the questions are going to be unfair, you're going to be motivated to comply with this. But if you're concerned that there may be something incriminating in your past that you don't want to share, or you're concerned that the questions you're about to be asked are not going to be asked in good faith, then you have to make that calculation. And it appears that the Clintons, in consultation with their attorneys, have decided to draw a line, and they are risking criminal prosecution, as we've discussed.
To that point, I mean, if you have nothing to hide and then you're seeing that Democrats are voting with Republicans here to potentially hold you in contempt, would that be enough to get them, do you think, would that compel them enough to testify? And can they still have that route? Can they still say, you know what, we hear you, we see this threat, we're actually going to testify?
At this point, they've been summoned, they've refused, and if the committee can prove that they had relevant information, they could move forward with the prosecution even if the Clintons offer to testify. If the Clintons do offer to testify, in exchange for that offer, they may be able to persuade the committee to drop the charges. But at this point, their refusal has already taken place. So it's a fait accompli. Whether or not they could negotiate, as you've suggested, a couple options for trying to present why the prosecution shouldn't go forward is an open question. I think certainly they're going to be pursuing that if possible.
And let's say, obviously there's a lot of hypotheticals here, obviously a lot can happen. Let's say the House supports to hold them in contempt, the DOJ prosecutes, they go to jail, they still refuse though to testify. Will they ever have to testify?
Well, at the what we're seeing unfold, Brittany, this is our system's recourse when a witness refuses to testify, whether it is a politician refusing a congressional subpoena or an everyday citizen facing a court subpoena. If a witness refuses to come to court and testify under subpoena, they can be arrested, they can be held in contempt, and conceivably they can be held in contempt every time they make a refusal. So if that's the context for the answer to your question, Brittany, because the answer is if they're subpoenaed again and refuse again, they can be prosecuted again. And that can happen as many times as it takes place. But there's no mechanism to force someone to open their mouth and speak when they don't want to speak. Now, they may, on the other hand, have an opportunity to take the stand and plead the Fifth Amendment, the right to remain silent. But of course, that doesn't look good.
And I want to talk about what exactly is next here. The entire House will vote on whether to hold them in contempt. And if that passes, it'll be referred to the Department of Justice and they'll decide whether or not to prosecute. But is a contempt case, is that pretty cut and dry because you just refuse to show up?
It's pretty simple. Yeah, it's as bad as cut and dried as you can get. It's what we sometimes call a process crime. And you do have to show willfulness. And so that, again, it doesn't get much more willful than writing a letter saying that you're not going to do it. So it's pretty cut and dried.
And specifically, as the attorney, what are you looking out for next year?
I'll be looking for any news that the Clintons' attorneys have made any of these overtures that you've suggested, such as a renewed offer to answer questions under oath behind closed doors, or perhaps even something I wouldn't expect, an offer to follow through with the hearing. And I think we should be looking for this soon, because given the political nature here, once the House refers this to the DOJ, I think it's a safe bet to say the DOJ is going to run with it.
And before Navarro and before Bannon, this was rare, right? Seeing someone actually face jail time and go to jail over contempt charges. Do you think, or a political official rather, do you think because of the political nature of how everything is right now, we will see this almost tit for tat where because Navarro and Bannon went to jail, that they will? But does that give the DOJ more of a boost?
Brittany, I think we are already seeing a tit for tat. We are in an era of partisanship and brinkmanship that is really unprecedented in living memory. And so I think the fact that Navarro and Bannon have already been prosecuted and sentenced for these crimes will certainly bolster the DOJ's position if they decide to move forward. And unfortunately, if there is another changing of the guard, we may see this continued tit for tat, as you call it. I think it's already begun, and it seems more likely than not that it's going to just continue.
Well, there's certainly a lot to look out for, and I appreciate your legal expertise here, breaking it all down. Phil Harvey, thank you so much for the time. I hope to have you on again soon.
Thanks for having me, Brittany.